Well, good morning, everyone, to those who are in the Southern Hemisphere, and good afternoon to everyone who's joining us from the Northern Hemisphere. It's fantastic to have attendees from all around the world today for the next in our series of the Ross Parsons Centre for Law and Business webinar series. Again, for those who are joining us from all around the world, thank you very much for giving up your time this morning or this afternoon. Today's topic is something which is of great interest here in Australia and has been for some time. It's the topic of small business restructuring laws. So those who are based in Australia would be aware, or may be aware, that we've had or currently having a review of our corporate insolvency laws with the Federal Parliament's Senate Committee on Corporations and Financial Services. And one of the topics that they've been very interested in, and a number of the submissions, including my own submission, have looked at this question of small business restructuring laws. And one of the things that the senators are very interested in is other models of small business restructuring laws that we have in other jurisdictions. And in some jurisdictions, we've seen some interesting experiments, you might say, in different features for small business restructuring, and maybe it hasn't worked as well as the politicians may have planned. But one country which seems, at least from an outsider's perspective, to have designed a law that is at least popular is the United States, with its Subchapter 5 bankruptcy procedure under their Bankruptcy Code of 1978. So that's the focus for today's topic, and I'm delighted to introduce our two speakers today. So our keynote presenter will be Professor Brooke Gottberg, who is the Francis R. Kirkham Professor of Law at Brigham Young University in Utah, the United States. And you can find her full bio linked on the Sydney Law School events page. And Brooke will speak for about 35 minutes. And I've specifically asked her to basically take us through how does Subchapter 5 work, and then to give us her perspective as an insider as to the view about how effective that regime is in the United States. And then our commentator for today is Mark Robinson, who is at De Vries Thayer here in Sydney. Mark is an insolvency practitioner and a former president of Insol International and a former president of ARETA, the local insolvency practitioner and turnaround professional association. And you can find Mark's bio on our website. My name's Jason Harris. I'm the director of the Ross Parsons Centre for Commercial, Corporate and Taxation Law here at Sydney Law School. And this webinar series, and also sometimes a seminar series that we run and have been running for many years, is really designed to connect researchers from all around the world, some of the world's leading universities, and to share some of their fantastic work with the local professional and business community. So without further ado, I'll hand it over to our presenter, Brooke. Thanks, Brooke.
Thank you so much, Jason, Professor Harris. I'm really delighted to be here. I would, of course, much rather be there in person. I have long wanted to come to Australia, especially Sydney. I've got lots of plans to get there eventually, but I'm delighted, and thank you to those who come. I want to quickly map out my agenda, if I can get there we go. So I thought I would introduce myself for in a little bit in addition to that generous introduction that was already given, to give you a sense of who I am and where my research is, and then talk a little bit about U.S. bankruptcy, specifically how it applies to these small and medium-sized businesses, and then go through the Small Business Reorganization Act, or the SBARA, which created Subchapter 5 here in the U.S., and then talk about whether or not it is working the way that we hoped it would. Okay, so first, by way of introduction, I found this on the internet. I'm really curious how accurate it is. This is meant to be a map of Australia for Americans. And you can see, so I'm actually from California, which looks like the southern tip of Australia there, but I, like many academics, followed the job, and I am working now for Brigham Young University, which is located in Utah, which looks like it's in the upper corner of South Australia. So I've never been there, but I'm assuming it's very beautiful with lots of national parks, probably somewhat arid. I don't know if it has mountains, but One feature of Utah is also that we have large mountains.
That's about the flattest place in Australia.
Well, so then maybe this map needs some amending, but nevertheless, I come from Utah. Much of my research interest has been with small and medium-sized enterprises on either side of the debt or credit relationship. So I've looked at how small businesses react to bankruptcy, both as debtors and creditors, and primarily through qualitative research, interviews with small business owners and with their attorneys, and to get a sense of their expectations for a process of bankruptcy, their reactions when they're involved in it. And it's interesting to me to see how the law, which is constructed by politicians and by those who are really steeped in the field, is perceived and is reacted to by those on the ground. So I promised Professor Harris I wouldn't spend too much time on background, but I do want to give you a brief overview of U.S. bankruptcy law by way of introduction to sort of set the stage for me. Much of the history of U.S. bankruptcy law and of U.S. history will probably sound very familiar to you. Like you, we were a former British colony, and we took with us much of English common law, and that included the law of debtors' prisons. But we ended up getting rid of our debtors' prisons fairly early on in the process. In the drafting of our Constitution in the late 1700s, we determined that the ability to pass laws on the subject of bankruptcies was essential to a solid economic working. And so we gave Congress that power to pass laws, uniform laws on the subject of bankruptcies. And our first law on bankruptcy was passed pretty early on in 1800. Now that law, so here's down in your lower left corner is meant to be a picture of the debtors' prisons. Now early on in 1800s, this was shortly after the Congress had been, or the Constitution had been ratified, shortly after the American Revolutionary War. Robert Morris, he's the image that you have on your lower right-hand corner, was considered by most to be the financier of the American Revolution. So he was the individual responsible for effectively gathering funds and acquiring capital that enabled the American armies to defeat the British. So he was close personal friends with George Washington, who was the primary general of the American Revolutionary War and our first president here in the US, and was well known to many of the founders. Well, after the revolution, he engaged in land speculation like many of the wealthier individuals in the US were doing. I have a map here of the US as it existed in the late 1890s. You can see the population centers were very much on the eastern side, but there's lots of land that we had acquired or accumulated by various conquests or purchases, and there's a lot of land speculation. So Robert Morris was engaged in this and had an unfortunate setback, I guess, in his finances, such that he ended up in debtor's prison. Now, you can imagine George Washington going to visit Robert Morris in debtor's prison. They decided pretty quickly that this was an unsustainable set of events, and so passed the first bankruptcy law in 1800 effectively to bail out those entrepreneurs, those speculators who had run into trouble. And for the next early part of American history law, that's how bankruptcy laws work. It was to effectively bail out entrepreneurs immediately following a boom and bust cycle of various kinds. But this plays into, hopefully, the overall culture or the overall understanding of US bankruptcy law, that it was viewed as an enabler for entrepreneurs to take risks. This notion that we want people to go out and speculate and take chances and take risks, and that will provide a safety valve of a sort at the back end in the event that we need protection. So this broader sense that entrepreneurship and risk should be rewarded, not punished, as with like putting somebody in prison. Following these years of back and forth with bankruptcy law, we had a permanent bankruptcy law installed in 1898. And then in the 1930s, we had a series of railroad receiverships. Railroads were not eligible to file for bankruptcy under the laws as they existed at that time. And so instead we had equity receiverships and learned a great deal from those about what would work and what wouldn't, such that when we passed the law in 1978, which is the current bankruptcy code that we have today, it incorporated a lot of the values that we had sort of internalized through these equity receiverships. So particularly with regards to business bankruptcies now in the US, we adhere to some particular values. And I'm not saying these are unique to the US, but they certainly characterize the US system of bankruptcy law. So first, this notion that we want to preserve the going concern value of enterprises, and bankruptcy should be used as a rehabilitation tool, not simply a liquidation tool. We have Chapter 7, which is designated for business liquidations. But Chapter 11 is primarily what people think of when they think of US bankruptcy law, and that is about rehabilitation. The second point is efficiency. My brother is an attorney, and he has practiced in bankruptcy court one time, and he said he got whiplash because of how quickly the deadlines moved, and this notion that we want to resolve issues quickly and cheaply, even if that occasionally means sacrificing the process. Now, that's a point that's constantly under debate, but nevertheless, efficiency is a major theme in looking at bankruptcy. Then we also have these notions of equity and fairness. We do want to ensure that similarly situated creditors are treated similarly, and that, to the extent possible, we preserve what value is available for them. And then the last point I have is limited interference with substantive rights. There's a great body of thought with regards to bankruptcy that views bankruptcy laws as exclusively procedural rather than substantive. And so primarily this gets translated into secured rights being preserved through the bankruptcy process. So if a creditor comes in with a security interest, that security interest will be preserved even throughout the bankruptcy process. So now I want to talk a little bit through what a business reorganization looks like under the broad umbrella of Chapter 11. So before talking about how subchapter 5, I feel like I need to set you up with what bankruptcy looks like generally, what a reorganization looks like generally in the US. The classical model for a debtor reorganization is as follows. We typically have voluntary reorganizations. It's very rare to have an involuntary filing, although those are possible. Instead, the debtor will voluntarily seek the protection of the bankruptcy court. Upon the filing of a bankruptcy, the automatic stay will kick in to stop any collection efforts on the part of a creditor, and stays in place until the debtor has had the opportunity to propose the plan of reorganization and hopefully get it confirmed. So I have got a label here for the debtor where the debtor, it says DIP, that stands for debtor in possession. Professor Harris said not everybody here is a bankruptcy attorney, so I thought I should probably clarify that's not intended to be insulting. That actually means a debtor in possession. So that means that the former management of the debtor gets to stay in place throughout the case. They continue to run the company, and they are also tasked with proposing the plan of reorganization. Okay, so the plan of reorganization is typically accompanied by a disclosure statement, which can be a long, detailed document. In the plan, the debtor will explain how we got here, what bad things happened that resulted in this bankruptcy filing, and they propose what we're going to do about it. Here are the ways that we're going to change to turn this around so that the company will be profitable going forward. And in the meantime, here's how we're going to pay people out. The creditors are divided into classes, and each class is expected to receive the same treatment. So because each secured creditor will need to be their security interest is retained, they're going to be placed in separate classes from unsecured creditors, and then any equity holders would be placed in their own class as well. So the disclosure statement, I've often heard compared to a prospectus, if you follow securities law at all, in a public offering, or at least in the US, when there is a public offering, the the SEC, the Securities Exchange Commission, requires that anybody who's going to do a public offering will make a great deal of disclosures to the public, and those disclosures have to be approved and vetted so that there's not an irrational exuberance about that particular stock. So the disclosure statement functions similarly, where the court will actually approve the disclosure statement before the debtor can send it out to creditors in anticipation of a vote. And that's the next step in terms of how this plan looks. So the debtor comes up with a plan that the court okays to be sent out to creditors. They send it out to creditors who then vote in by class. And you are required to have a majority within each class vote in favor of the plan in order for it to be confirmed. So in other words, not every individual creditor needs to vote in favor of the plan. You just need to have a majority within the class to vote in favor of the plan. And if that happens, then it can be confirmed. Now, it's also possible to confirm a plan when you don't have all of your classes voting in favor of it. So in situations where every class of creditor has voted in favor of the plan, we call that a consensual plan. But you can have non-consensual plans where, say, one class of creditors, let's take the unsecured creditors. We'll have a class of general unsecured creditors who might be made up of trade creditors, other businesses that the debtor's been doing business with. They say, no, we don't approve of this plan. In that scenario, the absolute priority would kick in under the US rule. And the absolute priority rule imagines or presupposes that all creditors are grouped in classes in a waterfall setup, sort of like I have here. And the idea is by priority, the money will trickle in as though it was going into a waterfall, and only once that cup has been filled will it spill over into the next cup. In other words, the absolute priority rule says secured creditors will need to be paid in full before unsecured creditors get anything. And then unsecured creditors will need to be paid in full before the equity holders get anything. What this usually translates into, absolute priority rule, is that equity holders get cut out. So if you are unable to propose a fully consensual plan, then equity holders sacrifice their equity. You bring in new ownership, new equity, and go from there. So that's how a typical Chapter 11 case functions. So now let me tell you why that was not working for our small and medium-sized enterprises in the US. Okay, so there were some issues when applying this Chapter 11 model to small and medium-sized enterprises. Kind of the first thing that came up was, for a lot of small and medium-sized enterprises, the ownership lacks much of the expertise that you would need to function as both a manager of a continuing company and as a turnaround manager, somebody who can come up with a plan, come up with a proposal to get the company out of the trouble it's in. So that this debtor in possession model was a little problematic. It's almost like the debtor just wasn't quite enough, and there was the sense that maybe the bankruptcy attorneys could help out, but bankruptcy attorneys aren't really specialized in turning a business around either. They are specialized in helping the debtor to propose the plan. So there was that issue. And then with the plan itself, the sense was that gosh, these Chapter 11 cases are just too expensive for most debtors. Putting together that disclosure statement, which was often hundreds of pages, in addition to the plan, and oftentimes the information was similar across the plan and the disclosure statement, but the requirements for the court were slightly different. Was just, it ended up being not worth the candle. Also, the Chapter 11 cases tended to be very long. It was hard to get a plan proposed in short order, even with the drive towards efficiency and the desire of the court to get these cases through quickly. It became a difficult matter. And along with that, there is the sense that there may be some cases that linger unnecessarily in Chapter 11, right? They might be dead on arrival, but it was hard to see that in the short term, or make sure that the debtor saw it in the short term and get the case dismissed. Then the whole model of having the creditors vote on the plan seems to run into some trouble in these small and medium-sized enterprises, because many of the creditors also lacked sophistication. The dollar amounts at issue were low enough that there wasn't much motivation to engage the way that there would be in a normal Chapter 11. We have a system in Chapter 11 generally where creditors can form committees, and this, this idea of overcoming the tragedy of the commons, or like a collective action limitation. You could appoint a committee, and the committee would engage with the debtor on the plan. In these small and medium-sized cases, it's just really hard to find people who are willing to staff a committee. And if you require a committee, that might be an unnecessary expense that's borne by the debtor's estate. So this concern that in these small and medium-sized cases, the creditor involvement is not the same as it would be in a Chapter 11 case. And so maybe it doesn't make sense to treat it the same. Then going over to the absolute priority rule, if you get rid of equity, which is the norm for absolute priority rule in a small and medium-sized case, you're usually not just getting rid of shareholders the way that you might in, say, a public company, but you're actually getting rid of the management as part of the equity. So you can imagine like Annette's pizza parlor. If you tell Annette that she can stay and run the pizza parlor, but she's no longer going to have any interest in the company because that's going to the creditors, you're probably going to lose Annette. Annette is probably going to want to go somewhere else and open a separate pizza parlor, which made the reorganization functionally impossible. So for many small businesses, Chapter 11 just didn't make sense for what they needed. Imagine a company that has $3 million of debt, a relatively small sum. It doesn't make sense to go through this expensive Chapter 11 process. But at the same time, we do have in bankruptcy law options for individuals to file a reorganization case. That's Chapter 13 is for individual debtors to reorganize. That can work for sole proprietorships. Sole proprietorships are treated like individuals under the law. And so you could have small sole proprietorships file under Chapter 13. Except that at the time, the cap on debt for Chapter 13 was 1.2 million. So you're talking a very limited number of businesses could file under Chapter 13, whereas there was a fairly large, window or category of businesses that didn't have enough debt to really make Chapter 11 make sense, but too much debt to be able to be eligible to file under Chapter 13. So I will say that cap for Chapter 13 has since been raised. It's currently 2.5 million, although that's 2.5 million for secured and unsecured debt combined. So the earlier cap was 1.2 of unsecured debt. Now it's 2.5 for secured and unsecured debt, which is still probably too low for most businesses to really be able to function on that. And again, it would have to be a sole proprietorship to work under Chapter 13. So we had these problems with Chapter 11 for our small and medium-sized debtors. So in a rare show of bipartisan support in the US, I don't know if you follow US politics, but that was meant to be a joke. It's very rare to have bipartisan support. Congress passed the SBRA in 2019, and it took effect in February of 2020. So this legislation created a subchapter 5 of Chapter 11, as Professor Harris mentioned, and that is how we refer to it as subchapter 5. So within Chapter 11, this chapter for reorganization, for business reorganization, you can have filers opt in to subchapter 5. To be eligible to do that, they need to have debts. Initially, it was debts under 2.7 million, more than half of which arose from the commercial or business activities of the debtor. And filers also had to be engaged in commercial or business activities. Now, crucially, they didn't distinguish between individuals and businesses. And individuals can file under Chapter 11 if they choose. Most don't choose to do so because they don't have debts that would make sense for it. But the way that this law was structured, you could opt into subchapter 5 if you were an individual as well as a business. And this was the language. Now, notice 2.7 million, that wasn't a whole lot. That was a pretty low cap. The timing of this act was fortuitous in many ways. It came right before COVID-19 really started to influence the US. So it was March of 2020 when everything started to shut down. And the SBRA had been in place for maybe a month. So as part of many of the acts that Congress passed for COVID relief, they boosted the floor, or sorry, the ceiling for eligible filers up to 7.5 million. So now any debtor with debts under 7.5 million can opt in to subchapter 5, again, so long as more than half of their debts arose from commercial or business activities and the debtor is engaged in commercial or business activities. Okay, so this subchapter 5 is intended to alleviate a lot of the concerns that we had with these small and medium-sized enterprises participating in Chapter 11. So for the debtor in possession, in addition to having their own attorneys, a third party, a subchapter 5 trustee is appointed for every case. Now that subchapter 5 trustee does not take over the debtor's management or responsibility, but he or she is intended to be there as an advisor, a facilitator, a mediator between the debtor and the creditors. And that role is still being somewhat defined, but it's that is, the subchapter 5 trustee was brought in to alleviate many of those concerns. They're often not attorneys, they're often accountants who do specialize in turnaround and can provide some business advice and a close look at how the financials look and what is realistic and what is not. The plan requirements, the debtor in possession is still proposes a plan, but the requirements for what is in the plan have been reduced. It's now, you provide some history of business operations, a liquidation analysis, and a projection of the ability to pay. But it's intended to be less onerous than the disclosure statement plan combination used to be. The creditor voting has become optional so that you can propose and get confirmed a plan without a creditor vote at all. You can still do a consensual plan, but you don't need to. And instead of the absolute priority rule, which has also been done away with, the requirement is that the debtor propose a plan that pays all company revenue minus reasonably necessary expenses, which can include salaries and other payments for the next 3 to 5 years. And that's actually a similar standard to what we have in Chapter 13 for individuals. Of course, the debtor will still need to pay off all of the secured loans. So that remains true in all chapters of bankruptcy. But for unsecured creditors, they don't need to get the creditors to vote in favor. Instead, they can just propose this, basically contributing all of their profits for the next 3 to 5 years. Okay, is it working? So that's what it looks like now. Is it working? Here's the record of the filings that we've had since the inception. So 4,630 total. So people are taking advantage of the program. On average, we have about 125 filings per month. It'd be alarming not to have any, but at some level, you don't want to have too many filings. That seems that would be the economy is not doing great. So 125. Nevertheless, that seems low to me when you consider the sheer number of businesses that we have in the US that count as small and medium-sized enterprises. So there's some numbers on the side, and also looking at a comparison of Chapter 11 filings overall. So you can see I have this chart that tells you, so it shows the sub 5 filings, the business filings for Chapter 11, and the non-business filings for Chapter 11. So those sub 5 filings would be part of those Chapter 11 businesses, right? Or the business filings. But you can see they're less than half, maybe even a quarter in some months would be these small business filings. So you could say, well, like the bigger cases, they often have lots of subsidiaries and conglomerates, et cetera. And so maybe that accounts for some of the discrepancy. But again, given the sheer number of small businesses, it seems clear to me we don't have as firm of an uptake on subchapter 5 for small businesses as we do Chapter 11 for large businesses. Now, part of that explanation might be that bankruptcy filings overall are very, very low. I'm curious to hear how they are in Australia at this period of time, but in the US, you can see it's a pretty straight drop from 2008 to now. There's been a long period of low bankruptcy filings. Now we have some theories about that. Maybe that's just the COVID-19 monetary stimulus. I'm curious to see these numbers with firm closures. I didn't pull together a chart for this presentation, but I suspect that There have been a lot of firm closures in place of Subchapter 5 filings. I just don't have all of that information. Something that I explore a lot in my work is the influence of bankruptcy stigma, and basically the willingness of small business owners to do anything that sounds like bankruptcy, or that has the word bankruptcy in it. But it's also possible that there's just insufficient information that companies haven't gotten used to, or attorneys don't know to advise them on the desirability of Subchapter 5. One more chart I have in here, you can see just the total bankruptcy cases just have dropped precipitously. So the small numbers that we're looking at for small and medium-sized enterprises may just be a function of the time. One last thing to look at in terms of how it's working. This information is pulled from the Rocky Mountain area. It's all of the Subchapter 5 cases in the past for 2022. And actually, it's kind of consistent year over year. What we're seeing so far is that we get about a 35% confirmation rate. In other words, of businesses who file, about 35% actually get a confirmed plan and a discharge to move forward. And the rest, you have conversions to Chapter 7, dismissals, and we don't know yet. So it's unclear how well this is working. To some extent, there's a fear that companies are filing when they're already dead on arrival. The Subchapter 5, it's unclear how much they are supposed to be encouraging reorganization or cutting debtors off at the knees if it looks like things aren't going well. And yeah, so I'll close out there. I think I'm already over my time, but I'm really looking forward to hearing Mark's reaction and getting a chance to engage with these discussions with the comparison of Australian cases.
Thanks very much, Brooke. I've certainly got some comments to add, but I'll save those till the end. So, Mark, what's your impression of the small business restructuring law in the US?
Oh, well, thank you, Jason, and thank you, Brooke, for a very insightful presentation. Look, I think most of our benefit will be through the comments in the Q&A session. So I'll keep my comments brief. I'll take it that I'm not going to explain the small business restructuring regime here in Australia because of that. But what I will touch on is what I see as the main similarities and differences as between the SBRA in the US and the SBR here in Australia. Certainly, the similarities are great. I think the intentions seem to be in alignment. In both Australia and the US regimes, they apply to businesses only, and that's or individuals in business predominantly. They're also both debtor and possession models, which is quite unique for Australia because we're predominantly a creditor-favoured regime. So it is a debtor and possession model, much like the SBRA regime. They're also similar from the point of view that they're some cut-down versions or simplified versions of an existing regime. Chapter 11 is your mothership sort of regime in the US. The voluntary administration regime under Part 5.3a is our larger, more complex regime, and Part 5.3b of our Corporations Act, where SBR sits, is essentially a subset, or attempts to be a subset of that and a simplification of that. The similarities also extend to, which is quite unique for a US regime. You've got a trustee appointed to assist with the process. Well, here in Australia, we have a restructuring practitioner, a restructuring professional, RP for short, that administers the process. So having a central point of control is a very similar feature. The other similar feature is, you've dispensed with in the SBRA, the vast number and complex creditor committees that you have running the regime. Similarly, there are no creditor committees involved in the SBR regime here in Australia. There's also, in both regimes, there's truncated periods of time involved, not just simplification. Here in the SBR regime here, the restructuring period is really, pardon me, just 35 days. We've got a 20 days proposal period from where the restructuring professional is appointed through to development of a plan and putting that plan to creditors. So a very truncated period of time. And further, creditors have only got to react quickly to that plan. They've only got 15 days within which to determine whether they wish to accept that plan or not. In terms of the plan period itself, we've got a cap of 3 years on that, whereas I note that under SBRA, you've got a 3 out to 5 year plan, and it's more based in and around return of profits over that period of time. So, great number of similarities. So where do I see some of the differences sitting? SBR here in Australia is a bit newer than SBRA. Our take-up is very low compared to the total number of restructuring style voluntary administration and related sort of restructurings that we do here in Australia. Somewhere only around 200 SBRs have been facilitated here in Australia. And that's put down broadly to a couple of areas. Our SBR regime is really not that simple. Whilst there's been an attempt to drive out some of the complexity in the VA regime, my personal view is that that's met with some limited success. So consequently, it's not that cut down from that point of view. And also the other reason for the low take-up might be is that our thresholds or the hoops that a business has got to jump through are both low and difficult. We're only talking about businesses with creditors of less than $1 million, excluding employee entitlements. So you can have employee entitlements above that. But that's a very, that's the micro end of SMEs. So it's a very exclusive. Also, to qualify for SBR here in Australia, you have to have your employee entitlements up to date, which for large employers is quite often part of the problem. You haven't got your employee entitlements up to date. So if you don't have them up to date, you don't qualify. Also, you have to have your tax lodgements all up to date. For small business, engaging accountants and other financial professionals to get your tax affairs up to date is not cheap. And also that's quite often the cause, or one of the causes for the failure in the first place is poor maintenance of financial records. So if you don't have your tax affairs up to date, you don't qualify to even start the small business restructuring regime. In terms of, pardon me, addressing complexity, Jason mentioned this in the introduction, that we're fortunately going through a review of our insolvency laws at the moment, addressed by a parliamentary joint committee, which is a committee set up by a federal government, a bipartisan sort of committee, reviewing corporate law. And these issues of SBR in and around complexity and these various difficult thresholds to get around in order to get through the gate to start the process, they're all being addressed and discussed with the Parliamentary Joint Committee. And early indications of that process is that those messages are being heard. So, things like increasing the threshold from $1 million up to something more workable. And we're talking Australian dollars, not real dollars, not US dollars. Getting that up to, something like 3 or 5 million Australian dollars. Will open up this procedure to a lot wider market, and hopefully the Parliamentary Joint Committee and whatever follows from that is listening to that message. The other main difference with SBR is absolutely no court involvement. It's a purely an administrative process. The directors of a business in distress go out and seek out a restructuring professional to help develop the plan and seek that restructuring professional's consent to act to facilitate the restructure. So unless there are some pre-SBR sort of court proceedings on foot, in an ideal world, a lawyer won't be seen at all. and so that it sort of does assist in terms of containment of costs. I guess the other key difference that I see is that we're not SBRs here in Australia. We're really, essentially, only dealing with one class of creditors to compromise, and that's ordinary unsecured creditors. And so we're not hung up about classes of creditors and where the various classes sit as between each other. And I'd be interested to know in the questioning as to how that sort of impacts the SBRA in the US. I also like, and I don't quite understand, and it's another feature of SBRA. Basically SBRs here in Australia are just purely like a cents in the dollar to one class of creditors. It's like an offer of 20 cents in the dollar to all unsecured creditors, take it or leave it. And that works really well if there are one or two large creditors, typically our Australian Taxation Office or federal revenue. If that plus one or two large trade creditors agree to that 20 cents in the dollar, it'll get across the line because it's a vote purely by a majority of admitted creditors to vote on the plan. But I note in SBRA you've got some other tweaks that you can do, such as adjustments to secured creditor arrangements in terms of reduction of interest rates and extensions of terms, with secured creditors, which I find interesting and could well be useful if they were seriously considered for our regime. That sort of concludes my quick snapshot of similarities and differences, and I might now pass to Jason to handle comments and Q&A. Thank you very much.
Thanks very much, Mark, and thanks very much, Brooke. Brooke, would you mind stopping your shared screen? Fantastic. We do have quite a number of questions, so I might take us through some of those. I also have some comments, but I might save those till the end. So the first question we have is from Amanda, who asks, Brooke, do you think the $7.5 million threshold will be continued after its temporary extension?
I do. So Congress voted to extend it. It had originally sunset, I believe, in March of 2021, and they voted to extend it. I think the expectation now is that it's going to be permanent. I haven't looked exactly at the language for when the next sunset is, but I believe the expectation of everybody who considers it is that it's going to be permanent at this point.
It's also interesting to think about other small business regimes. The one that springs to mind is Singapore. So they introduced a COVID-specific simplified liquidation, simplified restructuring, which was only supposed to last, I think, for 2 years or something. They then extended it to 4 years, and I think it's just been extended again. So, I say this is a great thing that too often in Australia, we introduce laws often with little consultation, and then we're kind of stuck with them. It can be hard to change some of these laws. So it's great to come up with, let's test this out, see if it works. So we'll set a sunset period. If it works, we'll extend it. We've got another question. Yep, sorry.
I was just going to say, I appreciated the reference to it's Australian dollars, not real dollars. That makes me feel legitimate. So thank you. I appreciate that.
When you come here, Brooke, you'll be pleasantly surprised at how far your real dollars take you.
That's great news. That's great news.
Okay, we've then got a question from Anonymous, who asks, what happens if the creditors don't approve the plan?
So if creditors do not approve a plan in a typical Chapter 11 case, you can push forward a plan if you can get one class of creditors to approve, and that's what's called a cram down plan. We use some evocative language in bankruptcy, so you cram it down the throats of the creditors. Yes, if there is one class that will vote in favor. And so cram down plans aren't used very frequently, but they are typically a backstop, like the threat. If you don't approve this plan, if you don't work with us, then we'll just cram it down. But if you do a cram down plan, that's when the absolute priority rule comes in. So a cram down plan equates to a sacrifice of equity in the Chapter 11 context. Now, in the subchapter 5 context, was a big part of what they did, is they facilitated cram down by getting rid of absolute priority. And so it becomes optional. You could ask the creditors to vote, or you could skip the voting process altogether and say, this is the plan that we're going to propose, and it contributes all of our profits for the next 3 to 5 years, and that's good enough. That much more mirrors like a Chapter 13 situation where the creditors don't vote on the plan at all. It's effectively the court that approves on advice of a Chapter 13 trustee. And so the subchapter 5 somewhat straddles this world between the Chapter 13 reorganization and a Chapter 11 reorganization that it enables, and the most successful plans, I think anybody would tell you, are the consensual plans, because that signals that the creditors are on board, that they want the debtor to continue. But you do have that option in subchapter 5 if you have creditors who are not particularly engaged or not particularly friendly, to just cram it down using a 3 to 5 year repayment.
So in that scenario, would the creditors who are actually dissenting would have a right to appear in the case, wouldn't they, and then oppose the confirmation?
Yes, they could argue against it. And there are other protections that we have in place that are consistent throughout Chapter 11, in Chapter 11 and subchapter 5. One of those being the best interest test, where it must be shown that creditors will get at least what they would in a liquidation scenario. So you need to show that you're paying a creditor out in Chapter 11 at least what they would have received in liquidation. That usually doesn't have a whole lot of teeth, because the liquidation, at least for unsecured creditors, the liquidation analysis is a zero payment. And so whatever you give in a reorganization is going to satisfy the best interest test. There's also a more general test that it needs to be fair and equitable, so not unfairly discriminate against a particular creditor. That in the general Chapter 11 case is largely subsumed by the absolute priority rule. And in subchapter 5, again, largely subsumed by this 3 to 5 year. Are you actually making the payments, like all of your profits going to creditors?
And from memory, you said during your presentation that there needs to be some sort of analysis of the debtor's financial capability to comply.
In the plan, that's right.
Yeah.
You'd have to do a liquidation analysis in the plan, and that is largely that facilitates that best interest test and communicates that to the creditors what they would get otherwise.
Okay. And my impression, I know we've got some people from the UK here, but my impression of the CVA regime in the UK is that often they fail because they're based on essentially a percentage of trading profits, and they're overly optimistic assessments of their post-confirmation trading profits. That's my assessment.
Yeah, it's interesting. I feel like we don't have the data yet to see if, these crammed down subchapter 5 cases are succeeding because they are actually able to, supply the profits that they thought they were going to supply in terms of the best interest test. That's one of many areas that is worthy of additional study.
Now we've got a question from Scott, who asks, what are the reasons that bankruptcy cases get dismissed, and what is the effect of dismissal?
So the bankruptcy cases that get dismissed, it's typically, it can be a variety of things, but it comes down to the bankruptcy court being convinced that there is no chance of successful reorganization. And so sometimes that may be because the debtor fails to respond to deadlines. Mark said that you've got a 35-day period to propose and get a plan confirmed, and that is shockingly short to me. So we give debtors 90 days to propose a plan, and you can extend it if you need an extension. And that's the shorter time period in the SBRA, right? In Chapter 11, it's like double that amount at least. But if a debtor fails to come up with a plan, and it doesn't look like there's any chance of them coming up with a plan, if they fail to file the necessary schedules in a timely fashion, if the attorney isn't answering the court's questions in a satisfactory manner at various conferences, the regularly scheduled conferences. So it could be a variety of things, but generally it could be the motion of a creditor, right? For a creditor saying this case is going nowhere, but generally it's the court not being convinced that there's any chance of a successful reorganization. It is an interesting, like a matter for further discussion, whether dismissals are happening quickly enough or with sufficient frequency, or too frequent, or too quickly. The subchapter 5 trustees that I have talked to have expressed the sense that, cases may be filed that shouldn't be reorganization cases. They're actually liquidation cases, but it's just like the debtor's not ready to give up. And so it lingers in subchapter 5 for a couple months while they get used to the idea of the company closing, and then it is either converted or dismissed. So as to the question of what happens when it's dismissed, it just gets kicked back to the state court regime. So under state court laws or under state laws, creditors can recover on a first come, first served basis. So effectively, whoever, the secured creditors can come and repossess their collateral. Unsecured creditors can obtain judgments and then liens and levy on their collateral. But effectively, you kick it back to lifting the automatic stay, and it's the creditor free for all that the collective action mechanism of bankruptcy was intended to avoid.
We've got a question from Eddie, who asks about how do director guarantees over the company's debt get handled in these types of cases? Is that a big issue in Australia? Because it certainly is here in Australia.
So, yeah, it is a big issue in the US. You're talking about personal guarantees by the owner managers of these companies. It's funny, but this has now come up, but in much larger Chapter 11 cases. It's generally been understood that the automatic stay will be extended to cover not only the debtor, but also those who are closely connected, closely affiliated with the debtor, like a parent company. That the automatic stay, once it applies to the debtor, will also apply to those around the debtor, so that the creditors' attempts to collect will not interfere with the reorganization process. So the reason I say it's interesting, because in cases like Johnson & Johnson, for example, or 3M in the US, the debtor was a subsidiary who filed and then requested basically an extension of the automatic stay to the parent company. And in the case of Johnson & Johnson, the court said, sure, that makes sense. That's consistent with what we've done throughout. And in 3M, the court said no, which has sort of thrown everybody into disarray. But I do think in these smaller companies, in these small and medium-sized enterprise bankruptcy filings, the standard is the automatic stay will apply not just to the company, but also to the owner. Now, that doesn't resolve the debt, right? The debt is still existing, but the hope is if the company can propose a repayment plan that will satisfy that debt, that also takes care of the personal guarantee. And so as long as that automatic stay remains in place for the plan to be consummated, then that personal guarantee will be taken care of. Now, if the plan falls apart, if you're not able to get it confirmed, then that often translates into a personal bankruptcy by the individual who's the owner manager, subject to that personal guarantee.
We've got a question from Bruce, who asks, how do businesses generally fund their trading during this period of subchapter 5? So is that just from their trading profits, or is there because we hear a lot in Australia about the dip finance and super priority and these types of things?
Okay, sorry, I got caught up on the term trading, but in terms of business operations, how does a company continue to? So yes, so dip financing is an essential element of Chapter 11 cases at all levels, including at the small and medium-sized levels. Frequently, in those situations, you'll have a secured creditor that has, we call it hog tying the debtor, has basically taken a security interest on all of the debtor's assets, such that anything that the debtor produces is cash collateral. And in order to use that cash collateral, the debtor has to get permission of the court or get the creditor to agree that the debtor can use the cash collateral. So in those situations, if you have an uncooperative secured creditor, or if you need an additional influx of cash, then you would look for dip financing. And the rules for dip financing haven't changed really from Chapter 11 to subchapter 5. In the early days of COVID, there was a lot of ink spilled and a lot of energy put into trying to make sure that we had this dip financing for this flood of bankruptcies that we thought was going to happen, and to ensure the liquidity. And I think everyone's somewhat surprised, although it makes sense in retrospect, credit was flowing very easily during those days and continue to flow very easily. I'm extremely interested to see what happens in sort of the next phase of this SBRA period, where I expect credit to tighten and this debt financing to be less available. And in those situations, there's been proposals made about what the Fed could do. The PPP, we didn't talk about that, and I don't know how much of that is common knowledge in Australia, but the Paycheck Protection Program in the United States was a major monetary, monetary aid tool to be given to small businesses, and it effectively allowed businesses to take zero interest loans or grants if they could prove that they used these loans to pay their employees, to keep their employees employed, even though the business was effectively not running. And so many businesses took advantage of the PPP, and as a consequence, just had a lot of liquidity for a long period of time. So, as we've been looking at these numbers and, the low rates of bankruptcy filing, a lot of that can be chalked up to just the PPP availability. But when it first came out, it wasn't available to companies currently in bankruptcy. And so there's some discussion like, can we change that going forward so that these kinds of loans can be available to bankrupt companies, and under what terms?
Okay, just having a look, a couple more questions. So Silky has asked, beside the differing thresholds that you mentioned earlier, what are some of the factors that might determine whether an individual debtor would want to use subchapter 5 or chapter 13? Is one shorter or does one have more beneficial features in your view?
So the general decision between chapter 13 and chapter 11, I like to tell students, is, are you buying off the rack or are you getting tailor-made? Because chapter 13 is much less expensive. The parameters are preset. You don't propose really a plan. The plan is worked into the information that you plug in. So you do have to say, like, here's all of my income, here are all of my expenses, including secured debt, and the result is how much I'm going to contribute on a monthly basis. And so it's kind of pre-made. Subchapter 5, I think would definitely be more costly. You have to pay for the subchapter 5 trustee who's appointed specifically for your case, whereas the chapter 13 seems to be a standing trustee who just oversees all of the chapter 13 cases. Also, the expertise that you would need for a chapter 11 attorney is going to be much more expensive than a chapter 13 attorney. So I think if you fall within the statutory caps, you're going to want to do a 13, unless there's something fancy you want to be doing with your case.
Interesting. Mark, what's your perspective on the same sort of question in terms of a corporate debtor in this case who could satisfy the sub $1 million liabilities and do a part 5.3B, but then could also use a full VA? Would you agree with Brooke's assessment there as a matter of Australian practice?
Well, yeah. I mean, if you can meet all the thresholds in part 5.3B, and because it is a low creditor threshold of sub 1 mil, and it seems out of the 200 or so SBR plans that have been approved and effectuated, that a dividend rate of about 17 cents up to about 25 cents the dollar seems to be the approximate amount accepted. So you're talking about a dividend of no more than a couple $100,000 you've got to come up with in an SBR. If you can qualify for SBR, my recommendation to a corporate would be go for it. But if you're beyond those thresholds and you've got a lot more bespoke and specific issues to deal with, VA is an incredibly powerful and flexible regime to be able to cut any deal or any type of deal with unsecured creditors at least. And so if you've got any unique features at all and you don't meet the SBR thresholds, I'd be pointing directors in the VA direction.
So if you want to do some sort of more complicated debt for equity swap type transaction, and we have a limited kind of cram down mechanism, Brooke, actually on the equity side under our full voluntary administration procedure, where if someone's coming in and recapitalising the business, you can get a court order to force the equity holders to give up their shares for nothing, as long as you can prove that effectively they have no value, which you can't do in a small business restructuring. So it's a little bit more limited.
Yeah.
Okay, we did have some further questions, but we have just ticked over to 9 o'clock and I'm mindful of everyone's time. So I'm sorry if we couldn't get to all of your questions. Brooke, thank you so much. That was a fantastic insight into something we've just kind of heard about here in Australia a little bit. We see references sometimes in newspaper articles and speeches by politicians. So it's been wonderful to get a sneak peek into how it seems to be working in the US. If I could just ask you this one final question, do you think on the whole, has the subchapter 5 been a useful addition to US bankruptcy law?
I definitely think yes. In fact, I think that there's, if you push me for an answer right now, putting aside all caveats about needing to do more research, et cetera, I would say I like the law. I think it's very helpful. I am concerned that the lack of uptake and the problems with it are external to the law itself, that it's more of a cultural aspect, that it's more of an information aspect. And there are things that we can do to improve upon it, but I do like the law the way that it currently is. I think it's a value contribution. I will say too, if you have additional questions, this has been so fun for me to talk about. Those of you who are on the webinar and had additional questions, you should feel free to shoot me an email. You can search my name, or it's just gottberge@law.byu.edu. But I'd be happy to answer further questions.
We did link your BYU page in the flyer for today's session. And of course, everyone online can also find both Brooke and Mark on LinkedIn. So feel free to reach out to them and connect. So on behalf of all the attendees today, thanks very much, Mark. And thanks so much, Brooke, for a fantastic presentation.